So thank you so much for joining us for today's Community Legal Centres Queensland webinar, which is on government supervision of funding agreements and the Sisters Inside case. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar in Meanjin, Brisbane. They're the Turrbal and the Yagara people. I wish to pay my deep respect to elders, past, present and future, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people across Queensland and a few interstate people as well, I'd like to pay my respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are joining us today. So I'm really pleased to welcome our presenters for today's session, Debbie Kilroy, OAM, CEO of Sisters Inside, Chris Mills, Director of Newman and Turner Lawyers, and Lydia Andrews, lawyer at Newman and Turner Lawyers. They'll be taking us through the Sisters Inside case and talking to us also about the background of the dispute, why it's important to, why it was important for Sisters Inside to resist the scope of the audit, the reasons given by the Supreme Court for deciding that the audit request was not valid, and the consequences of the judgment for other non-government organisations and community legal centres who are contracted to provide services by the state government, and possible future consequences of the judgment. So I'll hand over to our presenters in a moment and let them tell you a little bit more about themselves. But firstly, just some quick housekeeping. Today's webinar is being recorded and we'll have that recording available for you to download or view later this afternoon. The PowerPoints, hopefully we'll be able to send those out to you following the presentation and we'll put those online as well. And certainly we encourage you to ask questions. You can type your questions into the question box on the GoToWebinar control panel, and I'll read those ones out for our presenters to get to at the end of the session. So I'll now hand over firstly to Chris Mills to get us started. Thanks, Chris.
Good afternoon, everybody. Thank you to Community Legal Centres Queensland for asking that we present on this topic. This case was a bit of an unusual case in terms of the subject matter that we dealt with and the approach that was taken to it. At the end of the day, it effectively involved some administrative type powers, but the decision was based on contract because the government was a contracting party in this case, which makes the judgment a little bit unique in several senses. For the purposes of today, we'll be taking you through some background to the case. Debbie Kilroy has graciously agreed to join us to discuss sort of her perspective on how things went and the information that she's willing to sort of share about the background to the dispute and why this was important. Lydia will then take you through the judgment, and then I'll wrap up by discussing consequences, sort of both practical and legal, moving forward as a result of this judgment and the way that things might change moving forward. So with no further ado, thank you, Debbie. I'll get you to kick us off.
Okay, so I think I'm unmuted. You can hear me? Yeah, okay, thanks. Sorry, I can't see anybody other than Chris and Lydia, so it's a bit weird, this setup. But before I continue today, I'd also to acknowledge the traditional owners of the land. Here at Meanjin, I'd like to acknowledge elders, Turrbal and Yagara people, and acknowledge that we are unceded stolen land and that the ongoing genocide of Aboriginal people continue today, and we must demand land back so that we can commence the process of true healing in this country. I've been asked by Chris, who's been the Sisters Inside's lawyer since last year, and Lydia, to just give a bit of background. What you need to be aware of, though, is this is still on foot and hasn't been finalised. So yeah, I'll talk in that context, if you like. So as you may be aware, Sisters Inside is an independent non-government organisation. So we are not an arm of the state, and we don't practice being an arm of the state. And I think that everybody is aware that Sisters Inside works to abolish the prison industrial complex. So whether you agree or disagree with our politics and ideology and our actions and what we say is one thing, but we take it very seriously that we are independent from the government and we speak through that independence. Sisters Inside has contracts with not only the state government but the federal government, and we also have donations that are given to us through very generous people, and we've run campaigns over the years to raise money for certain aspects. For example, one of them was the Free Her campaign to end the criminalisation and imprisonment of Aboriginal women in Western Australia who were being jailed for non-payment of fines. Back in, okay, I'll go back a bit further. As I said before, Sisters Inside, predominantly me as the spokesperson of Sisters Inside, speaks out against government policy and laws quite publicly, and we don't hold back when we put our position, our policy position, out into the public arena. One of the most recent ones, which was last year, was when the terms of reference and the task force of the Justice and Safety Task Force for Women was established with Her Honour Margaret McMurdo leading the charge of that task force. We were very clear in our submissions with the Institute for Collaborative Race Research around the coercive control debate, and that coercive control must not be criminalised because we would see more Aboriginal women being pipelined into prison very quickly due to the racial gendered violence of policing in this state. The government didn't like our stance and took great offence to that. As that was bubbling along, we received a letter on the 8th of October last year from the Director General of DJAG proposing to undertake a financial and compliance order / review. We didn't have an issue with that. We're more than happy to comply with our contractual obligations. We audited annually like any other NGO. We also undertake an annual audit by the government through the Human Quality Services Framework that costs a great deal of money to us in the NGO sector. We also have a finance and risk committee that's established with management committee members and also an independent chair that is well known across this country in relation to her forensic ability around accounting. So we didn't have an issue. We knew that, well, it felt like, I should say, that what we were saying and doing and have been saying and doing, and particularly in regards to the coercive control debate, that it was being weaponised against us, and it's the time again now, back in October 2021, that this government decided to punish us. And to do that, they sent this letter for this financial and compliance audit, which I can imagine many other NGOs were quite worried about if that happened to them. What we were concerned about at Sisters Inside was the lawfulness of what they were requesting, what documents they were requesting. Basically, they wanted every piece of information really that you could possibly imagine for a number of years, which didn't make much sense to us, but also including Commonwealth contracts and in regards to our donations as well. And we did not believe that the state had the lawful power to do that. Now, some said to us, look, just give it to them, don't worry about it, and let's move on. Because it looks like if you don't give it to them, then something's wrong. And so we had great internal conversations about that. At that time also, we were seeking out lawyers to represent us, and we needed to find lawyers that had the courage to take on the state. I had spoken to a couple of lawyers that were interested, but when we actually talked about the more internal ongoings about the dispute and the relationship with the state and Sisters Inside, they would come back to us and say that they couldn't represent us because they were worried that they would not get contracts with the state in their own capacity as lawyers or their law firms. So that was a concern. I did speak to a friend that worked in the area as an academic and suggested Newman and Turner. So I spoke to them, and hence here we are, and we've travelled this journey together since last year. So what we decided to do was push back and say no, that we didn't believe you had lawful capacity or the lawful right or the reach that you say you have to have all the documents of Sisters Inside that you're requesting. So what we did is a couple of things. Our lawyers engaged an audit firm that came in at the end of last year and the beginning of this year and went through Sisters Inside and all its documents, did a big in-depth audit for our lawyers just to see if there was anything actually going on at the organisation. And from that audit, it was clear there were some minor things like dotting our I's and crossing our T's. For example, one of those was our management committee minutes needed to be PDF'd, signed off by the management committee and PDF'd. That wasn't happening. So they were the types of issues that were being raised by the audit firm that was engaged by Newman Turner. And we have resolved all those issues because all those little things are a concern to an NGO. We're not a big NGO, but we wanted to resolve those. At the same time, we wrote letters back and forth, our lawyers did on our behalf, and we engaged a QC, who's now a KC now, that we had conferences with. And so then we ended up in the Supreme Court. Obviously, this from the decision of the Supreme Court, then there was ongoing negotiations about what documents, which we were more than happy to hand over, that were lawful for the state to have. We set up a data room with that audit firm that we used and provided all the data into that data room where the auditors for the state have had access now for a couple of months, and we have still not heard anything back, and we are waiting obviously for some type of correspondence from the state in regards to that. So I can't really take that much further. So yeah, that's just a bit of the background.
Thanks, Debbie. I'm going to, as mentioned, my name's Lydia and I'm a solicitor here at Newman & Turner Lawyers. And I'm going to take us through the next section of the webinar. And we're going to look through the next stage of the matter and the Supreme Court's reasons for deciding the request by the State of Queensland for a performance review was not a valid request under the Services Agreement standard terms. So there are numerous reasons why to have a non-government organisation and not-for-profits providing various services funded by the government, to keep those separate and independent to the government. So NGOs and not-for-profits often provide a variety of services, including community, social, environmental, human rights and advocacy services. And importantly, not-for-profits often promote and affect social and political change themselves. So by ensuring that they're kept separate, not-for-profits are able to focus directly on the people that they support, free from the interplays of politics and governmental influence. There's an inherent resistance in the way that these services are delivered and the extent to which the government can interfere and influence those services simply because they're funding them. So, for example, as Debbie's just discussed, the work Sisters Inside does involves going into situations, fostering trust with women and their families and providing those support and services that they need. It's a trust that government entities and those workers often can't establish and are not able to create with those women. And in some circumstances, having the first-hand experience that Sisters Inside does with dealing with those systems, and in many cases having overcome the same challenges, is much more positively impactful in their lives. And similarly, community legal centres function in a similar way to protect people from the overreaches of government, ensuring their independence and ability to provide the services that they do the way that they do. So independence is important not just for the internal management of these organisations, but for the work that they do with these people. So of course, how do organisations deliver these services? Well, of course, through grants and funding, which are provided pursuant to funding schedules, contracts and services agreements. These agreements are designed to show the separation and independence through a contractual and a commercial relationship between the parties. In the matter of Sisters Inside against the State of Queensland, the government overstepped its bounds by requesting documents beyond the scope of what is permitted by the services agreement. Now, what we're talking about here is procedures, which, to be frank, a lot of the time can be a bit dry and a little bit boring to have to go through. But the issue here is that although it sounds procedural and unimportant, and what's the point of getting into the nitty-gritty of the difference between a performance review and an audit, these provisions in the services agreement are substantial requirements. And the reason we're so concerned with procedures is because they are the way to ensure procedural fairness is preserved and to protect organisations. So this matter is largely focused on 3 sub-clauses within the services agreement, and these are clause 12.1, 12.2 and 12.3. There are some other clauses which I'll touch on later, but these are the main ones here. So clause 12.1 provides a right to conduct a performance review for a very specific purpose, and that is assessing the extent to which the terms of the service agreement are being met and considering or recommending a course of action to ensure compliance or to seek a remedy of any non-compliance. So notice must be given under clause 12.1c, and that notice must specify the funding and the services that the state wishes to review. Performance review is a capitalised term, as you'll see on the slide, and that's defined simply as a review under clause 12 of any aspect of the delivery of the services or the use of the funding. Clause 12.2 provides a much broader right to conduct a performance review or an audit. There's emphasis added there on that or between the two. And clause 12.3 confines the subject matter of what can be requested if a notice is given. Specifically, full and free access must be given to accounts, records, documents, papers that relate directly or indirectly to the receipt, expenditure, or payment of the funding or the conduct of the services. Funding and services are also 2 defined terms, and they're both just constrained to any funding assistance provided under the services agreement. Other clauses within the agreement that are also of relevance in this matter was clause 12.4, which states that the state or its auditors must use its best endeavours to minimise interference when conducting a performance review or an audit. Clause 3.1 provides the general obligation on sisters inside to comply with any legislation and governmental requirements of them. 3.4 simply states that the conduct must be diligent, must be run effectively and in a professional manner. 7.1 states that funding must be used in accordance with the funding schedule and of course with any governing acts. And clause 21 covers conflicts of interest. So various requests were made up in the lead up to the hearing, including just 2 days before on the 25th of May 2022. So each notice varied slightly in their requests. However, the one on the 25th of May, they were all stated to be financial and compliance audits, except the 25th of May one was clearly stated to be a performance review under clause 12.1. The 25th of May request, was stated to be a performance review under 12.1, sorry. Over the course of the matter, we resisted certain changes to the scope of these requests. So for example, earlier requests by the states included that they wanted to review Sisters Inside's ACNC compliance. However, the state of Queensland is not the ACNC and they don't have the powers of the ACNC. And no regulatory notices or any sort of steps have been taken by the ACNC against Sisters Inside. So to review their ACNC compliance would essentially be somewhat futile and beyond the state's powers regardless. This request was later abandoned by the state, and Chris will be discussing that a little bit later on as well. So given the state revised its request on the 25th of May, Justice Brown only addresses the matters for determination by reference to that request. So as much as all the previous requests do have a little bit of relevance in the judgment, it's that 25th of May one that is of most importance. So turning now to the judgment, Justice Brown held that the state has overstepped its bounds by seeking to procure documents beyond the scope of what is permitted by the services agreement between the parties. It should be noted at the outset, and Debbie also touched on it as well, that Sisters Inside does not dispute the state's contractual power to conduct an audit or a performance review. Rather, Sisters Inside disputed the scope of the actual review and the purpose of the purported audit. or performance review. So behalf and Sisters Inside, we contended that the scope of the documents sought went beyond those that related directly or indirectly to the funding, as is provided in clause 12.3. Concern was also expressed that the state was not delineating between the services provided to Sisters Inside from funding which was funded by the state and those which are funded through other organisations and activities. So on behalf of the state, Mr. David DeJersey submitted that the state was not required to identify the motivation of their requests. The fact that there may be no documents that relate directly or indirectly does not invalidate the requests, and the fact that some categories of documents had been removed and now reinserted did not mean the request was unauthorised, and there was no material difference between a performance review and an audit. So the primary issues here for consideration are, firstly, is there a difference between a performance review and an audit and their processes, or are they actually just used interchangeably in the services agreement? And secondly, what is the state's purpose and what purpose is permitted under the services agreement? Now, the argument by the state that a performance review and an audit are the same is not accurate. So performance review is a defined term, and clause 12.1 provides a very specific procedure. So that is that notice has to be given, and that notice must specify the funding that's to be reviewed. And accordingly, Justice Brown held that the two are separate and distinct processes. So as stated in the judgment, an audit is given its ordinary meaning. So that's just an official examination of financial statements and a searching, examination, or solemn rendering of accounts. Arguably, though, the scope of documents sought does not change regardless of which process is undertaken. So if you undertake a performance review and an audit, clause 12.3 still both applies to both processes. It's simply just that the documents required may differ due to which process you undertake. So the processes to be followed for each differs, and they should not be conflated. They're two very separate, distinct processes. Now, the state must be clear about the process it has chosen, and that is the state's purpose in undertaking an audit or a performance review. So the pivotal point for an audit or performance review is the nexus to the funding and the services provided on the basis of that funding. Any purpose beyond that is not valid under clause 12. So on the slides, I've summarised the 4 different purposes that the state conflated in this matter. So by saying that the state must be clear about the process it has chosen does not mean the state cannot undertake all 4 of those processes there. It simply just means that the state can't just put them all together and say it's all just one big process. So for example, the state may wish to undertake a performance review under that first purpose. And if as a result of that review, there were some discrepancy in accounting practices, well then an audit process can be undertaken. So that the 2 processes flow on from each other there. Similarly, if there was any concerns brought to light by the performance review, they could be investigated either under the specific clause in the services agreement or, for example, under the Community Services Act, which I'll get to in a little bit as well. So the point is here, though, that they are all separate, very distinct processes. They each have their own way of working through different matters and investigating things or making sure or seeking a way to remedy any sort of concerns, but they're all separate, distinct. So what happened with here with Sisters Inside, with these 4 processes were converged into one, and Sisters Inside was not afforded procedural fairness. So from the first request on the 8th of October, it was stated that the review was being conducted as a consequence of a review of information provided to DJAG. So we requested details about these matters of concern, and DJAG later provided a list of 5 matters of concern on the 8th of April 2022. The matters of concern were high-level, very non-specific comments made by some person to someone within the government that were incapable of being adequately particularised as allegations. So they were just sort of comments on Sisters Inside. Now, although clause 12 does not require the state to identify their motivation for conducting the audit, By allowing these matters of concern to become its primary focus and what it was focused on trying to look into, the state turned a funding audit into an investigation. The alleged matters of concern not only identified potential breaches under the services agreement, but it also made reference to Section 16 of the Community Services Act. Now, the Community Services Act only relates to declared funding, which is funding the subject of a funding declaration. And after painstakingly trawling through all the government websites, funding declarations, and reading through all of the funding investment specifications, we were able to determine that only some of the funding that Sisters Inside receives is actually declared funding for the purposes of the Community Services Act. Now, for those unfamiliar with the Act, it contains a specific mechanism for raising concerns with an entity that is the subject of a funding declaration. So a serious concern under the Act is defined in Section 16 and includes serious risk that the declared funding received by the funding entity is improperly used, or if it's used for another purpose, if the funded entity fails to deliver the funded product or service, or an act or omission by the funded entity actually harms an individual. Now, the Act provides the Chief Executive may give a compliance notice to a funded entity to remedy a serious concern, and there are other enforcement mechanisms within that Act itself. So now if we go back to the services agreement, Sisters Inside must comply with legislation of the state in relation to the funding and services, and we saw that a few slides ago in clause 3.1 and clause 7 as well, I believe. However, not all the funding provided by Sisters Inside is actually subject to the Community Services Act. No notice has been given by the Chief Executive, nor any steps taken under that Act against Sisters Inside. And so, accordingly, seeking documents for this purpose of investigating and conducting a procedure under the Community Services Act, well, it falls well outside the scope of clause 12. Here, the state's purpose was an attempt to use a contractual provision to undertake what is a statutory mechanism, enforcement mechanism. So as there's no link between the requirements of the Community Services Act and other legislation that Sisters Inside is required to comply with under clause 3.1 and 7.1 of the services agreement, the request falls outside the scope. Now, the remaining matters of concern were ambiguous in their description, and it is not clear what documents needed to be provided by Sisters Inside to actually comply with any performance review or audit. They were too vague. So clause 12.4, of course, provides the duty of minimum interference, and there is an implied duty of cooperation in the services agreement. So accordingly, if the state wished to investigate these specific other matters of concern, more information needed to be provided, and a separate investigation process could be undertaken. Oh, that was that slide, sorry. A further issue with the 25th of May request was that it was stated to be made pursuant to clause 12.1, which is a performance review. So the 25th of May request did not comply with clause 12.1c in that it had not identified the funding and the services that they wished to review. Therefore, the request was invalid in that respect as well. Further, it sought to review matters for which the state had no power to review. And it was arguable that if the state had simply just held their position that they were conducting an audit, which, as Debbie mentioned, that was from the very first letter, that they were conducting a financial and compliance audit, not a performance review, that specific notice and identification of the funding would not have been necessary. However, as an audit is given its ordinary meaning, and the difference between the two is they are substantially different in terms of the documents that would actually be required and the purpose of what's been undertaken. So although the scope of the documents is the same, so that's being clause 12.3, the documents required may differ due to the purpose. So the key takeaway from the judgment here is that the pivotal point for an audit or performance review is the nexus to the funding by the state and the services provided on the basis of that funding. Anything further than that goes beyond the rights and obligations contractually provided in the services agreement. The state still has the right to conduct a process under the Community Services Act if they so wish, or conduct any of the other processes that we've mentioned here today. But if that process must be separate and it must be distinct to the processes provided under the services agreement. So in essence, what has occurred here is an abusive process such that they tried to merge 4 largely incompatible processes into one. Now, the state has a strong and important interest in the funding they provide to entities and the services that they procure from those entities. And if these services are to be delivered independent to the government and independent to political interference, then the state must be constrained to their contractual and their legislative rights, respectively. What this may mean for you is that knowing what's in your services agreements and knowing how they are specifically worded may actually be really of great benefit, particularly in circumstances like this, where the government department is seeking to overstep its bounds, particularly where protecting the interests of your organisation and the people that it serves are of primary and paramount concern. Thank you. I'll hand over to Chris now.
Thanks, Lydia. Now, those of you who have read the judgment know that it's quite short, but very dense. And that's probably obvious from the breakdown that Lydia's just given of it. I think we deal a lot with procedural issues, or dealt a lot with procedural issues in it, and more importantly, the substantive protections that the organisation gets by having those procedures put in place. So the big, how would you put it, throw it all together and then see what comes out the other end approach that was taken really converted into a very unfair process that I think, reflected poorly on the organisation in circumstances where it shouldn't have. And that sort of really led to the need for us to take action at the end of the day, particularly when it didn't look like it was getting resolved. So moving forward then, what does this judgment mean for other organisations and for the funding agreements generally? Well, Debbie mentioned at the beginning of this that there had been discussion about, whether everyone just throws their hands up and complies with the request because they're not going to find anything. We've got nothing to hide. We're all good people doing all good things. People should be able to see through that, but that's really not necessarily the case. You don't know what imperatives are sitting behind the administrative decisions that are taken by government. And if only it was as simple as to say that what was produced in writing was in fact the motivation that the government had for taking that step, but it simply isn't. And Debbie's spoken as well to some of the background issues there that the organisation considers had an influence in the action that was taken. And there's clearly in that sense sort of a little bit of perhaps a political opposition that has arguably entered into the consideration of the relevant decision makers, and I'll make some brief comments about what can be done about that towards the end. But in the first instance, the first issue that I want to deal with, I suppose, is what happens when or if a request comes to you from the relevant funding department. So let's say, for example, your letter comes through. It might come from the department itself. It might come from somebody who's been appointed by the department, like an auditor. And it's saying, look, here's a process that we want to go through. We want to have a look at your material and your documents. Provide all of this material for us. So the first thing you really need to be doing at that point is to ensure that the scope of any requests made by the government for production of the documents are appropriately constrained. In my mind, there are 3 big reasons that you want to make sure that they're appropriately constrained. The first is that excessive disclosure may give the state insights into your organisation that allow it to exert improper influence over it. So this is coming back to that point about, well, why don't we just let them have it? What have we got to hide? Well, here's one reason why that reasoning's not always going to be the right approach. So they can look into the organisation, they can learn things about it, and they can figure out how they can exert influence over it. Maybe that's innocent, maybe it's not. We don't know that, but we've got protections to avoid the toxic situations that can occur because of that. The funding agreements usually permit the state to use anything it finds in the course of an audit or performance review for other purposes that are relevant to its relevant functions. I'll touch on that again a little bit later, because that's actually a bit of a complicated principle that runs as a thread through the judgment. Finally, while there's often a requirement contained within funding contracts that requests for information should be no more onerous than is necessary to fulfil that purpose, audits or performance reviews can take considerable amounts of time and may affect an organisation's access to funding extensions or further funding opportunities while the process is being conducted. So once you get a request, carefully consider the nature and scope of the request, and then look at these things. Has the state settled clearly upon the process it has decided to follow? So in this case, has it decided to conduct an audit, a performance review, or something else? And are there any preconditions on the initiation of that process? So Lydia mentioned there that if they wanted to conduct a performance review in this case, they were meant to have given notice of particular things which they hadn't given. And it's specifically noted in the judgment as well that the revised Annexure 1 given 2 days before the hearing was invalid because it purported to change approach from an audit to a performance review without having given notice. Now, secondly, the scope of documents or information requested should pertain directly to the funding or provision of services, or in the case of the service agreement that we were looking at. Obviously, check your agreement to see whether it says the same thing. It ought to. It makes sense that it should, but check that scope. Make sure that it's authorised by the terms of the contract. And finally, is there sufficient clarity in the expectations communicated by the request as to what is required? And in defining the scope of the request, we need to ensure that the issues aren't ambiguous. Where there are issues arising from the request, I suggest it is appropriate to request clarification from the state. In fact, Her Honour suggested it was appropriate to request clarification in certain circumstances as well. Care should be taken as to the way in which clarification is sought. Her Honour noted in the judgment that the initial response by Sisters Inside disputing the scope of the documents had acknowledged that it still had a contractual responsibility to provide access to the information. Any response disputing a request for information, as in the scope of the request for information, should carefully avoid language that could be understood as a repudiation of the organisation's contractual obligations to provide information generally. Funding agreements will usually require the funded organisation to ensure it complies with any state or Commonwealth legislation, which we've discussed a little bit here. If statutory compliance is raised as an issue, careful consideration should be given to the applicable term of the contract. In the case of Sisters Inside, the state raised an issue with compliance with the requirements of the Community Services Act. However, as Lydia has discussed, there were preconditions to a finding of non-compliance under that Act that had not been satisfied. The time frame from which documents may be called upon is also relevant. In this case, information was sought in respect to both funding contracts that were presently on foot, as well as with respect to periods of time during which funding contracts that had since expired were active. The service agreement did not, however, provide that the obligation to provide documents for an audit or performance review survived the end of the funding contract. The judgment notes that earlier iterations of the request made by the department raised Australian Charities and Not-for-Profits Commission compliance as an issue at an early stage. Aside from being Commonwealth responsibilities rather than state responsibilities, the ACNC has broad discretion in its own approach to dealing with compliance concerns. An organisation may be technically non-compliant but maintain its registration subject to taking steps required by the ACNC to remedy any non-compliance. Given registration itself is the most likely precondition to eligibility for funding, it is not evident that there is any legitimate basis for the state to either preempt or second-guess the ACNC's approach to compliance. And similar principles arguably apply to corporate compliance. Actions taken by corporations or incorporated associations alike are usually taken to be valid unless they are invalidated. It is doubtful that the state could take advantage of the terms of the funding agreement to look into the validity of corporate actions that have no nexus to the receipt or use of government funding or the delivery of funding services. So to the extent that an audit or performance review request might be made to inquire into such issues, it would be prudent to respond to the request by affirming that the state parties' contractual rights, and the intention of the organisation to comply with its contractual obligations. Object, however, to the issues with which the organisation has with the request, the breadth of its scope, or the documents requested, or whatever they may be. Most service agreements should have an inbuilt review mechanism. If the state is not receptive to varying its request for information, identify the relevant clause of the service agreement and invoke it. The decision might then be reviewed by a person who had no involvement in making the original decision and should be accompanied by a statement of reasons. If a statement of reasons is not given and is not required by the terms of the service agreement, it might be worth considering whether the decision to request information is a decision to which Section 4B of the Judicial Review Act 1991 applies. Great. So Section 4B provides that a decision of an administrative character made or proposed to be made by the state or a state authority under a non-statutory scheme or program involving funds that are provided or obtained in whole or in part out of amounts appropriated by Parliament is a decision to which the Judicial Review Act applies. Section 32 then enables a person who is aggrieved by such a decision to request a written statement of reasons in relation to the decision. Depending on the kind of services funded, the ability to request reasons is excluded in respect of the categories of decisions listed at length in Schedule 2. In our particular case, it wouldn't have been excluded, but we didn't need to invoke this provision because we went the contractual route. If a reasonable scope that satisfies the requirements of the contract is provided, be sure to clarify that any documents containing information that falls outside of the scope can be redacted. The state may seek access to minutes, policies and other governance documents to the extent they are relevant to understanding how funding is managed and the services are provided. Given the state likely has the ability to use information it finds for other purposes, it may be prudent to exclude any irrelevant information from the material you do provide. Now I kind of pull all this together a bit for the last stretch here, because I think that there's an increasing need to object to excessive requests by government. There are political and other conditions that are sort of shifting a little bit, and I think in addition to all the reasons I've raised so far, there are other good reasons why we shouldn't just sort of sit back and say, look, we're good people. They'll be able to see that from the material. There's no need to hide anything. So the judgment refers to the need for the state to ensure it's clear about its purposes in instigating an audit or performance review. As Lydia mentioned earlier, this is to ensure the integrity of the processes that are followed and preserve interests of natural justice and procedural fairness that ought to be built into contractual processes and are built into statutory processes. However, purpose is a different concept to motivation. Provided the exercise of the contractual power is not capricious, arbitrary, and not in good faith, the state might have another reason to be looking at the information and will not ordinarily be prohibited from doing so. If we take the Associations and Corporation Act 1981 as an example, the recent addition of management committee members' duties, or the process of adding those anyway, gives the Office of Fair Trading an increased degree of oversight over the operations of an association. At the same time, both the Act and its regulations continue to hold on to anachronisms which are often overlooked. And if you haven't recently, it's probably a good idea to pick up a copy of the regulations and look for those anachronisms to see whether you need to update any of your processes. An order instigated pursuant to a funding agreement, if it's not properly constrained in scope, might give the state information about the management of an association which might be prejudicial to it and the members of its management committee. If an information request is appropriately constrained and is limited to information about the funding or the services, it might then be assumed that any evidence suggesting an issue with management of an association is necessarily incomplete. That is to say that the only information that they've been able to have a look at is partial information about the association, and therefore they can't make more broad assumptions about what that information means in the broader context of the association. The limitations upon the process itself are protective from adverse findings. The same assumption may not be made if the scope of the request is not properly constrained. Finally, an issue which has been the subject of much discussion in the charitable sector in recent times is that of advocacy. While political advocacy of itself is not considered to be a charitable purpose, charities may engage in advocacy activities that advance the purposes of that charity, while also touching on issues of political importance, as long as they don't fall within the definition of a disqualified purpose under the Act. There are two reasons that funded organisations who engage in charitable activity to which the government might have political opposition ought to be protected. I use ought as in they should be or probably are protected rather than in the ethical sense. The first is that the advocacy is often not funded by the government. If the advocacy is not funded by the government and on the basis of the terms of the service agreement with which we dealt in this case, the state ought not to have access pursuant to the funding agreement to information about that advocacy. It is noted that some advocacy groups are funded to participate in advocacy activities, in which case the second protection becomes relevant. The Anti-Discrimination Act 1991 lists political belief or activity as a protected attribute, and it prohibits any person who performs any function or exercises any power under a state law, or has any other responsibility for the administration of the state law for the purposes of the state government program, from discriminating in the performance of the function, the exercise of the power, or the carrying out of the responsibility. It should therefore protect an organisation from being exposed to discriminatory conduct for participating in advocacy activities that advance political beliefs that oppose the position of the government of the day. I might briefly note as well that there's a Commonwealth Act that is, I don't think it's well known. It's called the Not-for-Profit Sector Freedom to Advocate Act 2013. It actually prohibits the Commonwealth Government from including in, as terms of its funding agreements, any content which would prevent a charity from participating in charitable activities, charitable advocacy. I mention that now, but I've obviously been mainly speaking about the state government in this presentation. So, just to quickly wrap up, there are compelling reasons to resist inappropriate requests to access information about an organisation made pursuant to a funding agreement, as well as protections in place to prevent the abuse by the state of its powers. The decision in Sisters Inside case in the Sisters Inside case confirms that the courts will take a rigorous approach to interpreting the provision of funding agreements and preserving the contractually and statutorily entrenched protections about government overreach. This is consistent with the need to ensure that such organisations retain their independence and that their performance and service delivery is not a consideration which is subordinated to other objectives in assessing their entitlement to funding. So that's that. Have we got questions, Carly?
Thanks, Chris, and thanks also Debbie and Lydia for your contributions and for talking us through this case. There have been a couple of questions through. I'll just remind everyone that you can ask your questions by typing those into the question box, or you can unmute yourself to ask your question if you have a mic. So I'll just go to the first one. So Tara's asked this one directed towards Debbie, if you're able to answer this, whether you see a link between the coercive control submissions that you've done and the state's request for this audit.
Look, I think that we're never going to be able to draw an exact link to what it was or what was said by who at this point in time. Like, we're still undertaking legal processes to dig a bit deeper and to get this matter resolved, and maybe then something may surface. So, you know, it's not, I don't think it's unusual that this has happened to us. This happened to us, not this process, but a process back in June 2004 when we lodged a human rights complaint against the Queensland government at that time. We were actually then banned from every prison in this state, and I was personally banned. So the state takes, you know, its actions, political actions against NGOs about what we say and what we do at different times in a more severe way than other times. This one is about our funding, and, you know, even in making the decision to go to the Supreme Court was one that we didn't take lightly, because we knew that there will be consequences for Sisters Inside because we've done that. So whatever those consequences are, we don't know at this point in time, but I believe personally, and the organisation believes as an organisation, because of our experience with governments, that, you know, we will be punished in one way or form. It won't be presented as that, like that, so clearly, but we know, you know, that it's going to happen. But we couldn't let the state just do what they want to do when they want to do, when they don't have a lawful right to do it. Yeah.
Absolutely, thank you, Debbie. There have been a couple of comments that have come through, not questions, but just that, you know, thanking everyone for today's presentation, and particularly grateful to Debbie for sharing this important story and pursuing this matter. So the other question that I had is around the declared funding. So I'm curious about what sorts of funding would be considered declared funding under the Community Services Act, and whether there are any examples that you might be able to share. I'm assuming it is different to funding received under a funding agreement, but would be really happy for any insights you can provide.
Lydia's probably the best for that one. She did the deepest dive on it, because I can tell you it was an absolute mongrel to find. So yeah, I'll let her answer that one, I think.
Yeah, I haven't had a look at the funding declarations in probably a few months now, but off the top of my head, there was a total of 3 that I was able to find, the actual declarations. And it's just a one-page declaration, and then it references different investment specifications. So there is one for, I think, community housing or anything provided under that act. And then there's another one. It covers often things like youth justice. There's a women's one, and I think like sexual assault and things like that. There's a few listed in that. And then if you go to the investment specification itself, you have to look through and actually cross-reference the funding type, or the, I can't remember what it's quite called. There's like the funding type, and then there's also ones that have to do with specific people that you're helping. It's like 6 digits. And if you take that number and then you go to the actual funding schedule that you have, that's how you can tell if that's actually funding that's caught by the investment specification, which is in turn caught by the funding declaration. So I hope that somewhat answers it. But yeah, you just got to go to the funding declaration itself and actually trawl through the investment specifications to work out whether that funding is declared funding.
Look, it's, I guess, in a sense, meant to be sort of this extra layer of protection for funding that they've decided needs special protection. But they're meant to tell you about it. If you read your service agreements or your funding schedules and that sort of thing, it actually says in there, well, we'll tell you what they are. Well, they've never told anybody what these are, I don't think the department was actually able to really tell us what they were, and it wasn't until we spent hours just digging and following this rabbit trail of rabbit warren, I suppose, of different sort of odds and ends to finally line up the ducks and find out what they were. But the point of it really is that once you've got your declared funding, then the state can sort of monitor your compliance with the requirements of the funding agreement following the process set out in the Community Services Act. And like many government processes, it's got this inbuilt protection that stops you from an automatic finding of breach. There has to be a process that has to be followed. They give you a chance to sort of rectify any non-compliance, and that's why Her Honour in this one said, well, you haven't even bothered with any of that. And the reason, sorry, she didn't say this, but this is my commentary on it. The reason that they couldn't have bothered with any of that is because the issues that they were raising were so unbelievably vague that they couldn't be made sense of. But that's really what we're talking about there, is that there's certain funding which declarations should be made in respect of, that allows the state to sort of step in and say, look, we're concerned about the way that this is being handled. Can you take these steps to address our concerns?
Yeah, one other thing, just about whether you can work out whether the funding is a subject of a funding declaration. I think a lot of newer funding schedules tend to have the reference in it down on the page that you've got to comply with this certain investment specification, and then that's another way to go about it. But a lot of older ones don't make those references.
Yeah, so that's probably without spending another couple of hours on it, about as far as we can take that one right now.
No, that's great. Thank you very much. Robin has asked, they've said, while the merging of the review processes was clearly problematic, is the state able to engage in the review processes, so the separate audit and performance review processes separately, but at the same time, so concurrently?
Yeah, I don't see why not. It'd probably be more efficient if they did. In terms of they'd be getting all the information in at once, so why not do both things? But you just got to follow the process for each. And importantly for this case, you're limited in the information that you're allowed to look at. It's got to be relating to the funding or the service. We've said it a couple of times, but it just bears repeating. There was no objection at any stage by the organisation or anyone to letting the state look at anything that related to its funding. That was our very first position at the beginning, was simply look at your funding and that's it. So that's where we ended up.
Great. All right. Well, that's all the questions that have come through. Thank you so much. And I'll just check in with our presenters whether there are any final comments that you wish to make before we wind up today's webinar.
Sorry, I'm fine. Look, again, thanks so much, Debbie, for agreeing to be part of this. I think it was really helpful to have your story told in a way that I wouldn't have been able to. So
that's okay. Thanks for inviting me. And I think it's really important that those of us in the NGO sector protect ourselves as independent bodies. Otherwise, we just become merged into an arm of the state, and that's not who we are, and that's not who we operate for, and why we're established as NGOs. Sisters Inside is here to work with and alongside criminalised and imprisoned women and girls and their children and their families, and that's who we must protect. And the state can't have its reach into what we do and what we say, you know, and use that power, misuse that power. Yeah. So thank you.
Absolutely agree, Debbie, and I'm on behalf of all of the community organisations that have joined today's webinar and our own, thank you so much for coming along and sharing your part of the story for this. You know, certainly can't get that detail from reading the case, so it's been wonderful to have you here, and to Newman and Turner lawyers for sort of providing a nice, easy to follow overview of the matter. So I will finalise the recording now. Sorry, Debbie, were you going to say something?
I was just going to thank Chris and Lydia for walking alongside us. It's been really important, and how courageous they've been. Yeah.
It's been really great. I've been really pleased to help. So.
Yeah, and it's to be continued, right? It's not over.
Hopefully for not much longer.
Yes, I imagine so. We're keen to hear how it all goes and wish you all the best of luck with the continuation of this at Sisters Inside. And thanks everyone for joining us and listening into today's webinar. I'll have that recording out to you hopefully later this afternoon. Thanks again, and we'll see you at our next webinar session. Bye for now.
Bye.